For this evening, I want to thank you so much for joining us on Zoom, Facebook Live, and for those who are in the studio audience of Bedford Central Church. We are coming to you live from Bedford Central Church, 1200 Dean Street, where we're always trying to impact, making a difference in the lives of those around us. So thank you so much for watching, and for those who are here live, we are grateful. If you have questions, you can send them in the chat, and we'll be able to answer them and give them to the attorneys to answer them. We are grateful to have today the Hopkins with us. They have been impacting, changing. They have a very powerful Zoom meeting that occurs that many people tune into whenever they're on, to listen to their wisdom, to share their guidance with us. And today we are fortunate that they have come to be with us here at Bedford Central to drop some gems on how we can better prepare our estate for what the future holds for each one of us. We're going to pray, then I'm going to turn it over to them. They're going to lead us, and they're going to entertain some questions before they leave today. God, we thank you, we honor you that all things were created by you and for you. Thank you for the wisdom and the expertise that you have given to different people to do different things for your kingdom. So as we converse, as we participate, as we engage now, oh God, we pray that your presence may permeate those on social media and those in person, that our time here will be well spent. We give you honor and glory in all things, because you're the author and the finisher of our faith. In Christ's name we pray. Amen. Put your hands together, please, and welcome the Hopkins.
Thank you, Reverend. It's really a blessing to be here today. Really appreciate you having us. We are very happy to be here. My wife Sharon and I are attorneys, and we are, the name is actually Hoskins LLP, but Hopkins is usually, sometimes it's okay. It's a natural mistake that sometimes people make, but nevertheless, first of all, I just want to say what a powerful word today by the pastor. Very inspiring.
I enjoyed the service so much. Oh, I love the singing, because I was singing along. You saw me, right?
She was.
The band, the singers. I love it. I enjoyed the service, the message. So I find it a blessing to be here, even just for me. I think we got something out of it ourselves.
Oh yeah,
and
definitely.
Hopefully, listen to us, and it'll be a blessing to you, so you'll get information that you can use to make sure that you're in a better position, right? Because you're going to be positioned, right? So that you have a new perspective, you find your purpose, so that you can perfect what you need to do. Right?
Exactly.
See, I was listening. You see that? I was
That's
listening.
right. Yes, actually, and this is one of those moments when you need to be sober and take life seriously. Absolutely. So we'll get started. Just give you a brief background about us and what we do. I don't know if the slides are showing yet.
There we go.
Okay, so we'll give you a little bit of background about us and how we got started and why we do estate planning. We'll also talk about the things that you want to know. What is estate planning actually all about? There are 3 steps to planning, and we'll talk about that. How do you protect the things that you have? And then, of course, we'll, wrap things up and talk and take some questions. And we can take questions during, if something comes to mind, just raise your hand. That's fine as well. And we'll show you what the next steps are. Our process is a step-by-step.
And just for those who are watching on Zoom or Facebook, you can put your questions in the chat, and I guess they'll relay that to us.
Right. So, okay, so we can move on to the next slide. All right, so about us. These are our guys. This is our family. We have 3 sons. And actually, this is an old picture because we are now the 2 of the shortest people in the family. The third boy, he's now passed us up, and he's going to be a senior in high school. And so our oldest 2 sons are recent college graduates. As recently, the second son is just graduated on Thursday, from Queens College. So we're very proud of him. Thank you. And that's what it is about for us. And the reason why we're doing estate planning is because, as the pastor alluded to, sometimes families go through these things. When a loved one passes away, whether it's parent, grandparents, there's a lot of things that have to be done, and that's sometimes, unfortunately, when we find out things haven't been done. And then the family is left to try to figure it out. And figuring it out is difficult. And so for us, we both had issues with our parents. We knew, because we're attorneys, we happened to know that they had properties and they have assets, and we knew that as they grow older, we had to have some things in place. So both Sharon's mother and my mother, we created trust for them with the help of another attorney. And it was through that attorney that we realized that we need to get this message out, especially in our community, because a lot of what is happening is, as the pastor described, it's causing people and families to lose these assets, especially these homes that you may have had in families for years and generations. And so this is what we need to try to do to try to preserve that and to keep family legacies growing.
All right, so let's move on. Next slide. What we like to say is we try to promote peace in the family, and peace is an acronym for protection, education, assistance, comfort, and empowerment. So with all these things, you have the tools to set about a plan that works for you. Each plan is individual, and it's what works for you and your family to minimize and really eliminate the fighting that can happen between siblings when a parent dies, or other family members that they said they come up and they want, this is mine, where's my cut, where's this? Well, if you leave those instructions and make it clear, there's nothing for them to fight over. They might get mad, right? But they're gonna have to take it up with you when they get to the other place, whichever one they might be going to. So, but it's important that you make clear what it is that you want. And not only for when you pass, but even when you're still living, perhaps you are incapacitated and can't speak for yourself, then you need to have a plan in place that tells those who are caring for you what you want done with you. Okay, so next slide.
Yep, next. Okay, so, and this is, you can just tap on through to have each of the, yeah,
Just keep going.
thank you. So I know it's a little hard to see, but the folks at home can probably see it. So the things that people want to know when we talk about estate planning is essentially, how do we protect our stuff from the government or long-term care, and even from family, right? And of course, we want to know what a trust is. That's a word that's going around on social media. People are talking about it. What's a trust? Well, we'll talk about the differences between revocable trusts and irrevocable trusts, and the different kinds. And then also we want to talk about probate. What is probate? We've heard about that. Maybe we've gone through it. Has anybody had to deal with the probate court in their families? A couple of hands? Okay. So we'll talk a little bit about that. One of the other things that also comes up that we hear a lot about is, do I have to give my stuff to my kids, or should I? And we're going to tell you that you don't want to give anything to anyone that you love and care about.
Wait, say that again, Rob. What?
You don't want to give anything to anyone you love and care about. It
We'll
sounds
get back to
crazy, but there's a reason why.
I
And
see
we'll
those. I see those looks. What?
Yeah, it's crazy, but you'll see. You'll see. Now, if you do give your stuff away, what about, does it take 60 months for it to be safe, right? Well, 60 months, what's that about? Well, we're talking about Medicaid, right? So Medicaid, if you have long-term care needs, if you need to go to a nursing home, Medicaid looks back 60 months. That 5-year look back, that's what that's about. So we'll talk a little bit about that. Also, what about a power of attorney, the living will, or the healthcare proxy? What are those documents? What do they do? What don't they do? And what's the difference? And we'll talk a little bit about disabled beneficiaries, because it's not always about mental disability or physical disabilities. There's also some other disabilities that are out there. And estate taxes, that's the other big issue. Now, we'll talk a little bit about that, but like you and I, most of us are not really affected by estate taxes. Next slide, please. Thanks. So if there's anything else you want to know, like I said before, feel free to raise your hand, ask a question, and we'll do our best to answer it. All right. So 3 steps to plan and protect your estate. You've got to know the rules, know who your predators are, right? And then know the options, right? And that's what we try to do when we educate folks. You've got to know first of all, know the rules, right? And then the predators, what do we mean by predators? The people who are coming after your assets, you know, the government, taxes, your family sometimes. I mean, those people that might file lawsuits against you, all that kind of things. And then knowing your options. So I want to protect my stuff. Well, how do I do that? And we'll show you how we do that. Next slide. Okay.
All right, so first, when we talk about what the government rules are, these are knowing the rules. During your lifetime, there has to be someone who's going to speak for you at all times. Now, when you're well and in good mind and spirit and body, it's you, right? You're going to make decisions for yourself. But what if you can't? You should appoint someone, because if you don't, the government will do that for you. And it may be someone that you would not have necessarily chosen yourself. So you do that through a power of attorney. The power of attorney is a legal document where you appoint someone to act for you in legal matters and your financial matters. And it is valid for as long as you are alive. Once you pass, that form is no longer valid. That person can no longer act on your behalf, right? And you want to make sure that that power of attorney is someone you trust, because they really are acting as you. But you can change your power of attorney if you decide that you don't want that person anymore. You can simply revoke it and appoint someone else. Right? So that's the power of attorney. Then there's a healthcare proxy. You may have heard of this if you've gone to the hospital. They kind of throw some papers in your face and make you sign things. You know, we try to tell people, don't sign those healthcare proxies. Do one outside of the hospital, because you're in the hospital to get medical assistance. You're not there for legal assistance. A healthcare proxy is a legal document. You know, I don't write prescriptions. I don't expect doctors to prepare legal documents for you, right? So with the healthcare proxy, you are appointing someone to make your medical decisions for you when you can't. And that, again, is something only valid while you're still living, and then you can revoke it at any time and change who that person is. You may have heard of a living will. That's a little different from the healthcare proxy. The living will, it contains your instructions on whether you want life-sustaining measures to be given to you if you were to go unconscious. If you want, you may have heard of DNR. Have you ever heard of DNR? That stands for Do Not Resuscitate. And so if you sign an order like that you don't want to have any life-sustaining measures given, or perhaps you do, CPR, intubation, you want a tube feeding or IV to help sustain your life until they can find something that might, save you for as long as you can. Or if you can't, then at least there can be that they would have those instructions from you as to how long to try to keep you alive. Some people, we've had clients who we said, well, how long do you want to, would you want those measures? We had somebody who said, 2 hours is enough. We said, wait, can you give it a little more than 2 hours? Like, your family might want a little bit more than that. So they said, okay, 2 days. All right, so each his own. We had someone else on the other end of the spectrum who said 5 years. Right? So I said, well, I don't know who's paying for all of that for 5 years, but you have that flexibility to do what is right for you. I would say most people go anywhere between 30, 60, or 90 days, but you can come up with your own number. We had one who said 45, but then she thought that reminded her of Trump, so she said make it 44.
44 days, yeah.
She's like, I want Obama. So, but that's the living will. Remember, the difference is those are instructions on what you want to happen, but it doesn't give authority. The healthcare proxy is the document that gives authority to the person to work on your behalf to carry out those wishes. All right, so now I said a little before, what if you don't have these? You don't have a power of attorney, you don't have a healthcare proxy, what happens? Well, the government steps in, someone has to have a guardian appointed for you because someone has to make decisions for you. And so your family would go to court and file a petition to have a guardian appointed, and then the court is going to assign another lawyer to represent the incapacitated person, and then there's a whole trial that takes place. And your family has to pay for all of this, and it takes some time, and again, it's the judge that decides who actually is appointed as your guardian. And it may not have been the one you thought was going to be the one that you wanted. It could be any other family member, a person who's not a family member, and even a stranger, just another attorney that the court can appoint to serve as guardian for you. So that is taking control out of your hands. And we're about giving you the tools to empower yourself to stay in control. Yes. Well, in the case of death, it's a little different, right? I'm talking more about while you're still here and incapacitated. But so once you have passed, your spouse doesn't necessarily have immediate authority. If you don't have a will, or even if you do have a will, it has to go to the court, and the court has to appoint an executor to be in charge of your stuff. It's an executor if you have a will, and it's an administrator if you don't have a will and you die intestate. Mm-hmm. Yes. Perfect. You
That's
got
right.
it exactly right.
Yep.
Exactly right.
Couldn't have said it better.
Right. No, this is while you're alive.
This is while you're alive.
This
yeah.
is while
These are documents.
you may be in a hospital. You may be, and it may be temporary too. You could be in a hospital dealing with a situation, and maybe you're going to have a surgery, but then you come out and you're fine again, and you take back control. Or, it could be a situation where you're more in long-term care, and you do need someone who's going to be making those decisions and having a caregiver appointed for you, and you want someone to be acting in a way that you would want them to act. And you want to give them that information and those tools so they know what you like. When we do our plans, we do what's called a personal care plan, and that we get into details about what you like to watch on TV, what you like to eat. Do you want to go outside? Do you want to be taken to the parks? Or, maybe you don't like the park. Do you want to go to the beach? Or things that you like to do so that your caregiver knows how to make you comfortable and carry out. So you can live the rest of your days of here on this earth in the most comfortable fashion that you can, imagine and create for yourself. So that's, right. You have that exactly right.
Yep.
All right, next slide. All right, so that was while we're living. Now when we talk about upon death, that's where we want to know what are the rules in place then. If you have a will, your last will and testament, then you have appointed a person in your will to serve as your executor. That person has to take your documents down to the courthouse and have the judge appoint them as executor. And that process right there, that can take a couple of months. And then once they're appointed, then they start to try to carry out what the will says. And New York State requires that case stays open for at least 7 months so that the creditors can kind of swoop in and collect what they're owed. But does anybody here think that after 7 months, everything's all done? It's all wrapped up? No, right? Because if you dealt with it, it's at least a year. These days, much longer, really closer to 2 years. And I know people who are still dealing with after death issues 3, 4, 5, 7, 10 years out. And so that's when you have a will. Now, if you don't have a will, you still go through that same process, but it can take even longer because there's no instructions on who's supposed to get what. So who decides who gets what? The government. There's a statute that lists what the order of succession is and how your stuff gets distributed. So again, you don't have control. The way you get control is, the first step is to do a will, but there's something even better than that. And we're going to get to that. That's when we talk about trust, because you have even more control and it's immediate and you don't have to go to court to carry it out. All right, and so the other thing, that whole process that I talked about where you're going to court, that's what probate is. We threw around that term probate. You may have been like, whoa, what's probate? Probate is when someone dies and you have to go, it's a legal process where you have to go to court to make sure everything gets implemented and carried out. That's probate. And probate can be very expensive. AARP estimates that the cost of probate is 5 to 20% of the estate. So that's a lot of money being lost to just process fees and attorney's fees to carry out your will, or if you didn't die without will. Am I switching? So, and then the other thing about probate is that it's public. So anybody can go down to the surrogate's court and look up your information and find out what it is that you left in that will to all your relatives. And, Rob does the probate stuff. And
yeah. So, and this is a little creepy, but I filed a matter in Queens probate administration. Person died without a will, and I get an email almost 2-3 days later. Oh, dear attorney, if your client has any homes, I'm looking to buy it. Literally just days after I filed it. So there are people out there combing through the records every day, looking to grab up assets, looking to get the properties. And they know that the family's in distress, right? They know it's a vulnerable time for families. So, and a lot of families, sometimes they don't want to deal with the property, or they haven't been dealing with it. Well, now you have to deal with it. And a lot of people go through that. Sometimes if there's lots of people in the family, nobody can decide who's going to be in charge, or several people want to be in charge. So these are issues that come up. And as Sharon said, the public nature of it it gets a little creepy, because there are people that come around as soon as they find out that a death certificate has been filed in the surrogate's court. They're there ready to buy up or, take hold of your property, right out from underneath your family as soon as it's filed.
Next slide.
So, what's that?
That's you.
Oh, okay. Yeah, so anyway, I just, based on what Sharon was saying, just out of curiosity, does anybody here have an estate plan? Has anybody done any planning by show of hands? Well, actually, all of your hands should be up, right? Because as Sharon said, if you didn't put anything in writing, the government has done it for you. You have a question?
Yes.
A will is part of a plan. Okay. You need to
Yes.
update it. Sure. See, one thing we'll talk about is that wills and an entire estate plan is something that you need to constantly, deal with, because changes happen in your life, and we'll talk about that. Marriages, divorces, children's marriages, grandchildren, all those kinds of things are major changes in life, and that's when your plan has to be updated to make sure that, well, I need to, I need to make some changes. I have a new grandchild that's a new beneficiary. I want to name them specifically. Yes.
Question.
Well, yeah, it would be different because it's based on the laws of that jurisdiction. But essentially, wills and trusts are fairly similar, especially throughout the United States, but also in the Western world, they're fairly similar, but of course the rules are different in every country you go to.
But if you're living here, then you really should have one that's done here, particularly in the state that you reside in, too.
And if your assets are here, if you have assets outside of the country, there's ways to deal with that as well. Okay.
All right, so most of you have the government's plan, so you're not in control. We want to put you in control with your own plan.
Right, exactly.
All right, so now what are the predators that we talked about earlier?
So I mentioned predators. So the predators are the people that are after your money, not just the people that are looking through the records. There's those people, but we talk about, Sharon mentioned guardianship and probate, and we talk about a little bit about estate taxes. Now, estate taxes, the government's always looking for their share, no matter what, but estate tax thresholds are very high. In New York State, you don't pay estate taxes unless your assets are well over $6 million, right? So it's just over $6 million in assets on the state level and over $12 million in assets on the federal level. So if you're not in that category, then you don't have to worry about estate taxes. But then you never know. You might hit the Mega Millions or the Powerball, and then we work with you on that.
Keep hope alive.
Keep hope alive.
That's a new problem that wouldn't, not a bad problem to have.
Not
if
a
you
bad
got too
problem
much
to
money, you got to get,
Right. We just have to figure out how to shield it. Anyway, so one of the usual predators is also long-term care. Now, what are we talking about there? We're talking about nursing homes, right? So the thought of going to a nursing home is something that while you're fairly young and you say, well, I'm pretty healthy and I don't think that's ever going to happen to me, but I know my grandparents were in a nursing home towards the end of their lives. So you have to think, if you've dealt with a relative that was in the nursing home, that's a possibility for you as well. And the cost of care is extremely high. Even if you plan to stay in your home, I'm going to be at home, I'm not going to a nursing home. In-home care can be $500 to $10,000 a month, depending upon the level of care that you need. And if you do need, and assisted living is somewhere in between, that's an option. But if you do need nursing home care, nursing home costs are upwards of $15,000 to $18,000 a month. And I don't know about you, but I don't really have all that much money to pay for it. And certainly, if I did have the money, I wouldn't want my money to go to that, right? So we do have Medicaid, and Medicaid is our right to have care paid for by the state. So we can look at that, and, speaking about Medicaid, how many people have heard the term, Medicaid can take your house? Have you heard that one? Okay, so Medicaid doesn't take your house, but Medicaid has to be paid back for your care. And how it happens is Medicaid, once you have passed away and you've spent time in the nursing home on Medicaid, they take the amount of time that Medicaid paid, and that figure, that dollar amount, is then becomes a lien that's placed on your assets. So you don't lose your home while you're alive, but now your family takes ownership of your house. Let's say it's just your house, and Medicaid has now placed a lien on it. And again, at $15,000 to $18,000 a month, if you spent 1 or 2 years, we're talking $300,000 to $400,000 lien. So it's almost like another mortgage, even though you paid off your mortgage however many years ago. Now you're children have to deal with a house with a very large lien placed on it. And the only alternative that most families have is to then sell the property to pay that lien. That's where the taking of the house comes in. So while you're alive, while you're being cared for, nothing's happening with your house, but down the line, the lien could be very cumbersome and difficult for people to deal with, especially families. So how do we get around that? Well, we looked at, what it takes to qualify for Medicaid. You've got to give those assets away. And it's got to be done for at least 60 months so that Medicaid would not look at that asset. It would not be part of your asset base, right? So there would be nothing for them to put a lien on. And that's the 60-month look-back period to qualify. So, and next slide, please. Okay, so the unanticipated predators to your estate. Your spouse is one of the biggest, right? Because they are the one that has
They're
pretty
next
much
in line to take your
equal,
stuff.
Right, we touched on that. You have equal access
Whether you like
to
them or not.
to your assets. We look at, what happens if your spouse remarries after you're gone, after you pass away. Now, you have those assets. Do you want to protect those assets for your children, or does the new spouse get to benefit from your assets as well? Yeah, it is kind of crazy, but it's things to think about. Mm-hmm. Now, one of the we talk about is, when we talk about beneficiaries, the natural people that we think about are our children, right? Those are the beneficiaries that we want to leave the hard-earned assets that we have. That's who we want to leave them to. But what if your child has, we talked about disabilities, but what about being a spendthrift, or having a gambling addiction, or a drug addiction, or maybe they're just terrible with money? There's some people that if you gave them $100,000 in cash today, it would be gone by 5 right? Exactly, 5 p.m. So remember when I said you don't want to give anything to anyone you love and care about? Well, you may love and care about them, but you don't want to give them that $100,000. You just don't want to do that, right? And again, those are things that we look at as disabilities. They're not mental disabilities. Those are different issues. When people need SSI for, physical therapy, all those kinds of things, those kind of benefits. So we have those other disabilities, those addictions, those bankruptcies, prone to be accidents, those kinds of things. And also, one of the things with family is you want to support your children and grandchildren educations, right? So one of the things that can happen if you give your family lump sums of cash is that your children may be on scholarships, need-based scholarships in their education. But if you give them that $100,000, what then happens to that need-based scholarship?
Hi.
Disqualified, right? I mean, that's not what you intended. You intended for them to, what you want is to them to get the scholarship and benefit from the money that you're giving them. But we can't do that if we just give it to people. So there's different ways that we can accomplish that without outright giving it. And that's one of the predators, if you will. Yes?
You said if you don't give away an asset, you set it aside for that.
Oh, okay.
So that's a different, are you talking about particular plans like a 529, that kind of thing? Right. So with those plans, those, if you don't use it for education, and now they actually expanded it where you can use it for some other similar type expenses, but in order to get that money back, if you're not going to use it, you can withdraw it, but then you have to pay the taxes on it. So there's no way to get around paying those taxes on that kind of plan. But there's some more flexibility in those now. But
No, I'm going to ask please to just hold your questions because there are people watching via Zoom, so they can hear the questions.
They can't hear.
So afterwards, we'll give you a mic to ask the questions, all right?
Okay.
There are people watching. Thank you.
Okay. Didn't think about that. Okay.
Okay, so last one, lawsuits.
Okay, so, and of course, what we want to do is protect what we have from lawsuits, right? Lawsuits can happen to anybody at any time. We live in a litigious society, and I'm not going to ask if anybody's been party to a lawsuit, but if you're in business, you probably have been. If you're in business, you should expect to be. That's why we have insurance. That's why, we have business insurance. But those are the kinds of things that you want to protect your personal assets from, and creditors, people you borrow money from, credit card companies.
Or if you own a car, you're driving, you get into an accident,
Exactly.
you could get sued. Right.
You want to protect your assets from those type of things. And remember, again, why I said you don't want to give anything to anyone you love and care about, because what happens if you make somebody a joint account holder on your bank account? Well, you're subject to their potential predators. So if somebody sues them, your assets are at risk, right? And one of the things that always comes up with us, and I'll put it out there now, have you heard that, well, we can avoid probate, I'll just put my child on the deed.
No.
Have you heard that one at all? Yeah.
Bad idea.
Terrible idea. Don't ever do that. And if you hear anybody that you even care about thinking about putting their child on the deed to their home, tell them don't do it. Take the pen out of their hand, whatever you got to do, run down the street and let them chase you, because it's a terrible idea. And the reason why is because whoever you put on that deed with you becomes a co-owner of that home. They can mortgage the property without your permission. They can sell their interest without your permission, right? If they get sued by someone else, your house is now in jeopardy, right? And you don't know what could happen. And there's tax consequences to it as well. Lots of tax issues. There's potential capital gains issue for that child later on when they go to sell it. It's called there's no step up in basis. We go into some detail about that. But there are several consequences that you really don't intend to happen, even though it sounds like such a simple thing to do. And you may have heard of somebody that actually had done it, and but you don't know how they had to deal with it. Even though it sounds simple, it's definitely complicated.
So next slide. So we talked about knowing what the rules are, knowing who your predators are, and now we want to talk about your options. This is the part that you wanted to know, right? So first of all, there's the government rules, right? As you can guess, we're not a big fan of government rules. We would like to have you create your own. But that's the guardianship process, a will and probate process, and estate administration. Estate administration is when you don't have a will and you die intestate. So those are those rules that are in place. You can go with that option if you want. That's the option you actually have right now, right? So, but here are some other options. Next slide. So option two, we want to touch on the long-term care issue, because a lot of that's a big concern now. And I don't remember the exact percentage, but I think it's something like 62% of people are estimated will need long-term care. So long-term care, we're talking about not just nursing homes, right? It's nursing homes, there's also your at-home care and even temporary care in a nursing facility or rehab facility. Who's going to pay for that? You can privately pay, right? If you've got the money to do that. again, I'd rather spend my money on a trip or something that's going to be more fun. You can get long-term care insurance, and that's definitely something that you should look into. And if you can qualify for that and afford it, because it can be very expensive, then that can be a part of your plan. The other component is community Medicaid, right? That a lot of people say, well, I want Medicaid to pay for it. So community Medicaid is when you're staying at home and you're having the person come in. And you also may, if you're a veteran, you have VA benefits that'll give you a stipend to pay for some of your medical expenses each month. And if you are able to qualify for Medicaid, you can get those expenses paid. But how do you qualify, right? How do you minimize the cost so that you can qualify for Medicaid and have it paid for? I bet you would be shocked if I told you you could have $2 million net worth. And if you structure your assets correctly, you could still qualify for Medicaid. Right? Doesn't that sound crazy? It's doable, right? It's the way you structure it. So, and some of the ways we do it with it's very detailed. Each situation is going to be different, but it can be done. But as long as you do it early, because there's that 5-year look back. So anything that you may have transferred to somebody else or given to somebody else, within those 5 years, Medicaid is going to say, well, that's nice that you did that, but we're going to treat it as if you didn't and act as if you still have that money in your possession. And so we're going to give you a penalty, and we're going to say that, say $100,000 that you gave away, well, that'll cover about 7 months in a nursing home facility, so you're going to be penalized for those 7 months. And you're going to have to pay for that yourself, somehow. So that's what those are things you want to do in terms of setting yourself up, pre-plan. You pre-plan by one, you do a trust, and you're going to talk about next, the asset protection trust. And there are other expenses that you can cover that are exempted from being looked at by Medicaid. Even your home is actually something that's exempted if you're married. If you're single, it's not exempt. And that's where we come into, if you did nothing, they'll let you keep the home while you're alive, but then they'll come back and put that lien on it and ask your family to pay for it. So some of the other options we call it vertical planning because you're still standing, right? That's when you can do the pre-planning and you do it 5 years out. What's coming up that is going to affect a lot more people with the in-home care is that starting April 2024, there will be a 2.5-year look back on in-home care services through Medicaid. So that means the same way they do the 5-year look back for nursing home care, they're going to do a 2.5-year look back for in-home care. So that's going to affect a lot of people. And I'm talking about, you hear the commercials, so you can get a loved one to come in and care for you and we'll pay for that. That's community care. It's all of that stuff. So you have to be mindful of that 2.5-year look back and start planning for that as well. Now, if you are in a situation where you're doing what we call horizontal planning, because you're laid out and you can't do it yourself, then we call that crisis mode. And you don't have the 5 years or the 2.5 years even to do a pre-plan. So there are still things that can be done. So you see on the slide, under crisis planning, there are those exemptions I mentioned. We make sure anything that can be exempted, we exempt, right? And we find there are also some loopholes, like if you have an adult child who lives with you as a caregiver, that's another way to exempt your home. There are different exceptions that apply. But then you want to spend down your assets. So you can do things like lots of home improvement, renovating your home to make it comfortable for you to stay there and be able to be safe and comfortable in your own home. Things like attorney's fees for doing your estate planning, funeral expenses, paying for that in advance. All of those things are costs that are allowed and will be exempted from your whole estate, so you're minimizing the amount of assets that are accountable to Medicaid. So those are different things to do. And then there's these pooled trusts that are set up where you put the money in to cover your expenses. They're paid each day, and that, again, is taken out of the Medicaid box so that your assets are down to zero, and you can qualify sooner, right? As long as you meet the other qualifications, where you have to have certain medical issues to qualify on that end. So there are a number of things to get to do. I can't go through them all. We'll be here for another 3 hours. And again, it's very specific to your situation anyway. But just know that there are things that can be done and that should be done as soon as possible so that you can maximize the possibility that you can get beyond that 5-year time period and where all of your assets are protected from Medicaid. You get to keep them. You pass them on to whoever you want. I said pass, not give. Pass them on to whoever you want, and it stays in your family. You're leaving a legacy. You're maintaining that generational wealth that we talk about, we want to build. It was great to build it, but you got to maintain it. And that's what we want to try to get people to do. Next slide. All right, so I'm going to let Rob take this. Yeah. How do we create our own rules?
All right, so creating your own rules. I was just talking to another attorney yesterday, and we talked about the tax code. The tax code in this country is written for businesses. It's written for the wealthy. And the wealthy have businesses and they have trusts. That's it. That's what they use. And those are the two beneficiaries of the U.S. tax code. And it was an interesting discussion because this is how assets are protected for generations to generation to generation. Now, we use a trust, and let's talk about the different types of trusts that there are. First type of trust that can be created is what's called a testamentary trust. And that's a trust that's created through your will. So in a will, you would put language that says, I'm going to have my executor create a trust and all my assets are going to go into that trust. And when that trust is created, then the trustee will then pay my beneficiaries and distribute all of the assets. That's great. That's great for you when you pass on, and for some people, that's all they need. But what does that mean? It means the trust doesn't get created until after the probate process. Remember, we talked about that. Long, expensive, drawn out. Property still has to be maintained until that executor is appointed, and then the executor has to get around to creating the trust, and then blah, 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 blah. And the payments to the lawyers keep going up and up and up. And I'm happy to take those payments, but there's a better way to do it. That's a testamentary trust. And also, it doesn't help you during your life. So how do we protect you while you're alive and while you still have and are using these assets? Well, there's two types of trust. One is a revocable trust, and that, you can see, is the open box. We call it the RLT. The open box means you can put your assets in it and you can take your assets out anytime that you want. So let me back up just a second. So in creating a trust, there's 3 parties to create a trust. And a trust is a contract between the 3 parties. There's the grantor, that's you, the person that owns the assets. There's the trustee, the person that is going to maintain and control the assets. And then there's the beneficiary or beneficiaries. Those are the people that are going to eventually get those assets. So there's 3 parties that are involved in the creation of a trust. And in the revocable trust, you are all 3 people. So you can say, well, okay, if I'm all 3 people, why do I need it? What's the point in doing that? Well, the revocable trust is helpful in case of the worst case scenario. If you put your assets and title them into a revocable trust, it will protect your family, or your beneficiaries will get the assets right away in case you pass away. There will be no need for probate. There will be no need for them to go to court. The assets will pass directly. So you could say, well, you mentioned, putting my child's name on the deed. That'll do the same thing, right? Right, but if you put your house in the trust, it won't have those other effects that I mentioned on the beneficiaries. The property will go through the trust right to the beneficiaries, because when you pass away with a revocable trust, that open box then becomes closed. right? And now, only the trustee, the successor trustee, if you will, can then just go ahead and transfer the property. So, that's what a revocable trust can do. Now you say, well, wait a minute, you guys just got finished talking about Medicaid and long-term care and 5-year look-backs and all that kind of stuff. Doesn't it protect me from that? The answer is no. Revocable trust does not protect from lawsuits, Medicaid, and the 5-year look-back and all those things. What we have to do is, in order to get full asset protection in those instances, is create what we call an irrevocable trust. And an irrevocable trust means that you cannot change it. It's permanent. You put you title your assets in the name of an irrevocable trust. You cannot take it out. Right? It's that closed box in the middle of the other 2 boxes there. All right? So, well, what does that mean? Do I have to give up control of the asset? No. See, the types of trust that we can create, you can still maintain control. You can be the trustee of an irrevocable trust. You can actually, if you own property and you rent out your property, you can still receive the rental income from that property.
Rob, what is that little faucet thing on that box? What does that mean?
Yeah, see, whatever you put in an irrevocable trust, there's a little faucet on the side, which means you can receive the income or the gains from stocks or whatever it might be that you have. Though that income can go to you personally. Now, well, then the question is, well, what do I put in an irrevocable trust? If you're telling me I can put things in, but I can't take them out, but I can take out the income, well, what does that mean? You're putting in the thing that you want to protect, right? So what we tell clients is, what we're doing when we sit down with you is we're settling your affairs today, while you're alive, while you're thinking straight, when you know your kids, you know exactly who's married to who's what, and how they are. You can decide today, you know, I have this house, this is a family house, I'm never going to sell it. I want my kids to have it, I want my grandchildren to have it. If that's what you want, then that's how we proceed, right? So we put in the things that we want to protect. So that family house or that sum of money goes into the irrevocable trust and you don't touch it. Why? Because you don't need to. Because you have it. And that's why you want to protect it, because you have it. You don't intend to sell it. Now, if you say to me, well, Rob, if I put all my assets in a trust, what if I want to sell something? You know, what if I want to move to Florida? What if I want to, yeah, okay.
Not Florida, not anymore.
No, okay, well, maybe not Florida now. But, so what you can do is you can change the asset, you can sell an asset, but you have to leave the value inside the trust. Because your beneficiaries, remember, are a party to that contract and they're owed that in the future. That's why you're putting it in there. Now, if you don't ever want to sell it, then an irrevocable trust is the perfect thing. Now, what does an irrevocable trust do? It gives you that protection from Medicaid. It gives you protection from lawsuits. It gives you that asset protection while you're alive. See, even if you have a business, your business can be owned by your trust. That gives you another level of protection from liability. How many people have LLCs? Anybody? That's a big thing. Okay. I'll just say this because this is another off topic that we could go into, and we don't have the kind of time, but LLCs are business organizations. They are not asset protection vehicles. Okay? Trusts are.
And I know we only have about 3 minutes left, but
Okay.
I wanted to add on the other things you can do with the trust is, remember I talked about instructions. You always want to include instructions. You want to protect against somebody's remarriage because you don't want it to go to the new spouse or to the other kids of that spouse. You can put those instructions in there and it protects it against them. It protects assets from divorce, right? So if your child gets a divorce, you want to make sure that asset went to your child, not to the in-law and their children, right? So it keeps it in the family, your bloodline, for who you intended to go to. So those are some of the other things that you can do, because you have those instructions in there. And then next slide.
Okay,
I'm
yeah,
sorry.
we can move on
Oh, okay.
to the next slide. Yeah.
You do that.
So real quickly, so now you've got your trust created. Now what do you have to do? Your trust is that little red wagon. You've got to put your assets into the wagon. You have to integrate it, because we have several people that come to us and say, oh yeah, I did a trust 10 years ago, but we never did anything with it. We don't have anything in it. Well, it's just paper then. It's meaningless. So you have to put your assets in retitle. It's what we call funding, and it's the next step in the trust process. I kind of talked about joint accounts a little bit, and beneficiary designations. When you put somebody on an account, we kind of covered that a little bit. That's not integration into your plan. So you want to make sure those things avoid probate, but that's not part of your plan. You want to make sure when you do a plan, you integrate it fully. All right? Next slide, sorry. So, what happens next? Now, if you decide that you want to meet with us, what we do is we have a vision meeting. And the vision meeting is where we discuss your goals, because the way we approach this is that we want to know what's important to you and your family, what it is that you want to do. We're not the type of lawyers that are going to tell you, law, then you make a decision. No, we want to know what it is you want to have accomplished, and then we give you the options. And we lay out the different types of plans that will help you achieve your goals. And that's how you get what's missing and get that protection for your assets and for your family going forward.
Next slide, please. So if you want to come in and have that vision meeting, I have a number of QR codes. I think if you are able to move the video, thank you, perfect. So what we ask you to do, those at home and those here, I don't know if you can do it from this far away. Use your phone to scan the QR code. We have an evaluation form if you'd fill out. If you fill that out, and if you signed in on the sheet that we passed around here, and you want to do the vision meeting, it's complimentary because you sat with us for this time. That vision meeting is complimentary. Come in at no charge to give you the first steps and give you your options to create a plan. We also have some handouts to give you information about what we talked about. You can scan that QR code there for that. And also is the code for our scheduling calendar, so that you can just go directly there to find a date that works with you. We can meet in person. Our office is in Long Island. We're in Westbury, Long Island. But we can also meet via Zoom, right, if that is something that needs to happen for you and is more convenient. And finally, we have another workshop coming up on June 8th, if you want to share it with any friends and family. That's that fourth QR code that's up there. That is via Zoom as well. And
we go into a little more detail. Not too much more detail. It's only about half an hour longer than we've spent here. But a little more detail and more opportunity to ask questions and feel comfortable. It's extremely important to us to share this information with our community. Sharon and I are both from Queens. My parents grew up here in Bedford-Stuyvesant. It's important, we see what's happening out here with homes, with deed theft and all these different things. And we've got to be vigilant. We've got to help. And as attorneys, we want to protect our community too. Yeah, question.
Okay.
Sure.
Hear me clearly, please, and for those who are watching, those who want to ask questions, come, because we have one mic. Come here, come to the center. You're not giving your whole story. You're just asking a question. So, all right, we have 10 minutes. Come, Sharon, you'll be the first one here, because people on Zoom are listening. Just come and join the line, please, and one after the other, those on Zoom. If you have personal questions, they can be around for a little while. You can come and talk with them personally. We have 10 minutes for questions. Just ask a question. Please don't tell your story here. Just ask a question so they can answer speedily. And here, but don't leave, because I want you to be able to take a card with you, a number with you, so you can, as I did full disclosure in the beginning, that these are persons that I use for my own estate planning here, and they were incredible in helping me to get my life together financially.
Thank you.
Yeah, my question is, I think there's some banks, when you have mortgages, I think there's a statement in the mortgage that says, if you put the house in a trust, I guess the mortgage comes due.
It's a great question. Well, the answer to that is no. It's not true. There is federal law that prevents banks from calling in the due on sale clause in mortgages if you put your house in a trust.
Okay.
Now, here's the tough part. If your house is in a trust, some banks make it difficult for you to finance or to get second loans and things like that. It's that some financial institutions are reluctant to lend to homes that are held in trust. But if you move your house into trust and it has a loan on it, they cannot call it due.
Okay. Thank you.
You're welcome.
Thank you. Hello. Hello.
Hi.
So, when you have a trust and you put up the trust for collateral to the bank, my question is, so if the individual pass away, then the bank is in control, or they're just taking the portions of what was loaned against the trust?
So you're saying the property is in trust and they get a loan from the bank?
No, so, okay, so I work for the bank, and I do commercial mortgages.
You
But-
gotta use the mic.
Oh, I'm sorry. And I do commercial mortgages, but the trust is not, it's a revocable trust. So that's what they're putting up as collateral.
Okay.
Well, the collateral would be whatever assets are listed in the trust.
It's listed in the
Right.
trust, okay.
So again, if it's a revocable trust, remember, that does not offer protection from lawsuits or creditors because, like I said, it's an open box. So if you can get the assets out, then they can also access those as well. So if someone is going to put assets that they hold in trust up for collateral to secure another loan, then those assets are subject to that loan. The trust really is just the vehicle that holds it. I mean, otherwise, all of the rules are the same.
Can the trustee of an irrevocable trust also be the beneficiary?
Well, yes, they can. But it has to be, the grantor cannot be the beneficiary, but the trustee can. So the grantor can be both grantor and trustee, or it can be trustee and beneficiary, but you can't have grantor and beneficiary. You follow me?
Another
Okay.
question. So if you have an LLC, should you dissolve it and just put it under the irrevocable trust, or are there benefits of having two separate things?
You can put the LLC itself into the trust. You don't have to dissolve it.
Okay.
Right. Remember, the LLC is the business. So remember, a trust is not a business. An LLC is a business. And if you're operating your LLC as a business, and this is one of the things that we're going to start doing a little more, because I know a lot of people have LLCs, you have to do the paperwork in order to have the LLC protections, right? You have to do the biennial submissions and so forth. You have to operate it as a business. If you don't, there's what's called the alter ego doctrine. And I don't want to get into that because it's a legal thing. And trust me, it means that if a judge finds that you have an LLC, but it's really just your personal thing, then you don't get the protections that an LLC provides.
Hi, two questions for you. The legal costs you mentioned for a will probate, you said it's between $5,000 and $20,000. It could
20%
5% and 20% of your assets.
of
Right.
the, right, of
Okay.
the total estate.
Okay. For a trust, what is the cost? Where, you know, in comparison to that? One, and two, if you have a trust, you said you can't take out assets. Can you add assets to that trust as you go on?
All right, so the second question first, the quick answer is yes. You can always add assets to the trust. And if it's an irrevocable trust, once you add it in there, you can't take it out. But you can certainly
can.
you can completely add it any time. And then the first question was the
Cost of
the
the
cost.
trust.
So it depends on which type of trust you're getting. And the thing to understand with the trust, you're taking the cost now, right, to save later what you would have to protect an amount from later. Meaning, if you're going to put your house into a trust, and your house could be worth, say, $250,000 up to $1 million. You know, in Brooklyn, it can even go
million.
higher, right? So you're spending anywhere from, and I'll tell you, it'll be anywhere from $4,500 up to $10,000, depending on the trust you choose, to protect $1 million asset, right? So that's less than 1%. Right, as compared to probate, where you're spending 5 to 20% to distribute those assets. So it's more cost-effective to spend the money now and get a plan that is under your control with your instructions that's protecting your valuable assets now, rather than waiting till later where anything can happen and you're spending a lot more money in counsel fees to deal with it.
A big hand, please. A big hand for our presenters. They are available. You can come and talk with them. You can get their cards or information so you can be in touch with them. But they are extremely, extremely, extremely effective. Make sure you take a card before you go share with somebody, because this is where we are lacking as a people in making sure that we have some knowledge. And we are grateful. We're going to say a prayer for those who are watching, and then we're going to allow you to come and talk to them personally, or get a card before you go so you can share it with somebody. God, we thank you for your wisdom that you have given to others to give to us. We are so glad for this opportunity to participate, and we recognize now that we have a responsibility to pass it on, because we as a community is in dire strait because of a lack of knowledge. We pray, God, that the wisdom we learn will impact us, inch us along in making wise decisions. In Christ's name we pray. Amen. Thank you for watching. Thank you for coming. Come please and talk to them personally. They'll be more than happy to share with you. Nia, make sure you come and see them. You have too much money, Nia, to walk away. Come on, Miss Sean Shepherd John. You have too much money to walk away.